After spending 1,557 days
As I understand it,
Helen's care, yes, Your Honor.
let me ask you a couple questions about the delay, because that is an important issue that I think any moral person who looks at this case. How many times did your client object to any setting of any hearing in the juvenile court? I think the answer is 0.
The answer is 0 or perhaps 1 walk-on where there was not proper notice.
So they never objected to the setting of a single hearing.
Correct.
And as I understand it, in terms of appellate court delay, first of all, the resolution of the most recent appeal was resolved in, as I recall, is the most prompt resolution of an appeal in the history of the Second Appellate District. We set aside an order in connection with the placement order, where the facts were just backwards, the findings were just backwards. We issued a preference order in the first appeal, and the most recent writ petition within 30 minutes, of which is the one that challenged the order not to discuss the matter with the press. Within 30 minutes of that having been filed, we had issued a state order of that order. So I think your argument is that there's delay in the trial court, not in our court, at the Supreme Court, correct?
Absolutely.
And so all of the delays, at least in the juvenile court, your clients acquiesced to, correct?
We did not acquiesce to
Well, you
delay.
never objected. Your clients were represented by counsel, never objected to a single delay. Isn't that a fact?
It's not true.
When did your client ever say, when a judge said this is set for March 25, Your Honor, we object?
Well, the first...
He earlier admitted that it never occurred. Isn't that a fact?
That what never occurred, Your Honor?
Never objected. You certainly raised the issue of wanting...
We never objected to a set hearing to postpone it. I'm sorry, I misunderstood the import of your question.
Incidentally, I'm not accusing your clients of some craven conduct at all. They did this because they thought it was right.
If I may address your question.
Because they love the child. I think we'd agree about
Correct.
that. But there's an intellectual dissonance when your clients didn't say, well, there's all these delays. But we never once said, Your Honor, this hearing date is too far away.
It's on the record.
Because it was in their interests. It was in their interests. Because they had the kid with them, the child with them. And they did so because they loved the child.
We sought an expeditious hearing on remand from this court's 2014 decision. And what respondents did is they recused Judge Amy Pellman from the case. We objected strenuously to that. Nonetheless, she accepted the 170.6. The case was eventually reassigned to Judge Trendacosta, and we urged an expeditious good cause hearing because under this court's 2014 decision, we were confident that we would win. We didn't want delay. We wanted permanency, and we were thwarted at every turn. What happened instead is that the court failed to set an expeditious good cause hearing. Instead, it ordered increased therapy and escalated visits for a child without a hearing as to whether they were in her best interests. And finally, 7 months later, or something to that effect, ordered a 7:30 evaluation of the child, having denied or deferred decision on our request for a bonding study, which would have been highly relevant to this court's 2014 disposition in this case.
Well, I deeply respect your arguments about that. I do.
I appreciate that, Your Honor.
And I respect your client's motivation in not objecting. I respect that too. But I think we have to be clear that your clients never objected to a single hearing date. I think I'm right about that.
We sought a hearing date.
The
court failed to respond.
But they never, when the judge said the hearing date will be on, I'm using March 28, February 29, whatever, they never said we object, this is too long.
We did, and I think it's reflected on the record that we continue to...
What date was that? Just tell us the date.
I think that in the current record before the court, there's a reference to the fact that since December of 2014, we had been urging a setting for a new good cause hearing.
I'm just talking about objecting to a date that's set by the court. Well,
Your Honor, it's hard to object to a date that's set by the court when the court refused to set a date, with all due respect.
I don't agree with you about that. Do you? I object.
We made a record on moving more expeditiously, and the court refused to do that. And then held a hearing in September, which, as you've noted, resulted in, a a lengthy presentation with expert evidence, at the end of which the court took 2 months to render an opinion that repeated the exact same legal errors that this court had already corrected more than a year prior to that. We moved as expeditiously as possible to get that order vacated and appreciated this court's treatment of our stay petition as a petition for peremptory writ in the first instance, which this court granted. And we moved as expeditiously as possible once again on the second remand. I think it's fair to say that respondents have twice imposed significant delays by removing bench officers from this case, even though the second successive removal was not authorized. And we objected to that at every turn. We tried to move as expeditiously as possible because, frankly, under this court's 2014 decision, there is no question how this case should have come out.
Can I ask you a timeline question?
Yes.
So, when was the Utah family identified as potential adoptive family?
They were identified to the court in November 2012, which was approximately 11 months after Alexandria was placed with my client.
And when did your client first request the hearing before Judge Pellman? The good cause hearing. When was that request made?
I believe that request was made contemporaneous with their request for de facto parent status, which would have been around the same time, as soon as reunification efforts were terminated in October 2012.
So would it be fair to say that from the point in 2012 that an adoptive family was identified, all the delay that followed was the result of a request for a good cause hearing? And the litigation of that, which unfortunately went through several cycles, but all of the delay after that is simply as a result of the request for a good cause hearing.
I mean, I think most of the delay, but as mentioned, I mean, there was significant delay between this court's 2014 decision and the next time we got a legally erroneous decision below that was not due to the request for a good cause hearing, which of course happens all the time in these cases. You have to contest it and ask for a good cause hearing, or you just relinquish the child. And I don't think that this court penalized appellants last time in 2014 for having had the temerity to seek de facto parent status and to request that hearing. And given that the delays are not, were not as a result of a failure of diligence on the part of appellants, I don't see how it's relevant.
I'm just trying to get the time.
Yes, okay. I understand.
When was the Utah family approved? When was the interstate compact approval?
Judge Pellman noted in her original December 2013 opinion that she had ordered expedited placement, and the ICPC, I believe, was approved around that same time, the initial ICPC.
Would you be making the same good cause argument if the minor were in your client's care for 10 months?
Perhaps. I mean, the first good cause hearing was requested and de facto status was granted when she had been living with my clients for approximately a year. And given her prior instability and the success that she had in their home and the parent-child bond that she had formed at that point, yes, I mean, those arguments were made at approximately that time. And Judge Pellman felt like it was a very difficult case.
Is there a length of time that you would say is too short to make the good cause argument that you're making before us? I just gave you 10 months and you said perhaps. I don't want to get into a back and forth with numbers, but can you give me one where you'd say 4 months is just clearly insufficient to be making the good cause argument that I'm making?
I'd hate to throw out a number like that because I think it depends on a number of things. First of all, you wouldn't have foster parents with standing unless the court had made a determination that the child had been in their care for a substantial period of time, and that they were fulfilling the role as a psychological parent. So that's a prerequisite for sort of making this argument in the context of a foster care situation. I think typically those arguments have some force once the child, depending on their age and development, has clearly formed a bond to them as a primary caretaker. And I think that's going to vary on the facts of the case and depending on the age of a child. So I would hesitate to put a number on it. But I think, this court recognized in 2014 that the amount of time, then 2 years, was quite significant, and that, and remanded for a determination of whether the significant risk of harm to Lexi would satisfy the good cause exception. This court instructed, in fact, that the lower court had erred in requiring that there would be certainly some harm, and also instructed that Lexi's individual best interests had to be taken into account. That didn't happen in this case.
But what we didn't get into, though, was what the nature of the bond or attachment has to be to satisfy good cause. In other words, we said you have to consider what that bond is, but we didn't pass it all on whether it needed to be extraordinary, whether it needed to be a specific time. And so I was just interested in your views on that.
Well, I think it's undisputed in this particular case that the bond is both primary, strong, healthy, long-standing. It's in fact, it's a set of facts and circumstances that are, in some ways, an outlier, because the cases in California and nationwide find good cause based on bond and attachment in circumstances where the bond is much less long-standing, or where there are debates about the strength of the bond the child has had prior, primary attachments, etc. We don't have that in this case. It's utterly undisputed that this child has viewed these people as her parents and this family as her own for years. And there was a fundamental failure on remand to consider that in a significant way. There are things the 2014 opinion doesn't address, but two things that it does that failed to happen here is that the court was supposed to consider whether there was a significant risk, not a certainty, but a significant risk of serious harm to this child. The court found there was a risk of, quote, trauma, but nevertheless decided, without reference to any of the expert testimony in the record, that appellants failed to carry their burden on that point. This court also instructed that, yes?
You refer to the facts here as an outlier. Is there any authority that you know of, anywhere in the country, where a court has ruled as a matter of law, either for removal of an Indian child or placement of an Indian child, where the court disagrees with the position of the minor child? What I mean is, in this case, we have counsel for the minor, who's also guardian ad litem, took a position contrary to your client. We can't find any case that's ever held that where a minor child through counsel, a guardian ad litem, says, I would like to be placed here, the court has found an abuse of discretion as a matter of law. Can you cite any authority anywhere in the country that's ever ruled against the wishes of the minor's counsel?
I cannot, and I think there are a couple of reasons for that. At the juvenile court level, of course, decisions are not published. So those are not decisions that we're able to search and identify cases of the nature. And we have looked, and I think the answer is that we failed to find a case where minors' counsel has actually urged removal from a long-term placement that is healthy and working after such a substantial period of time. So you don't see the minors' counsel in other cases opposing deviation from the good cause exception. We've failed to find any case where minors' counsel urged the removal of a child from a fit long-term foster placement of any similar duration to what we're talking about here.
Aren't there cases where there's been delay in identifying an adoptive family, a year or two, and the courts have affirmed placements after that? Not.
They've affirmed good cause determinations,
Right.
And sometimes the tribe is litigating on the other side, but I've never seen a case in which Minors Counsel has said, yes, we must move the child pursuant to ICWA after a long-term placement of that nature. I would add, though, the facts were the same in 2014. This case reversed for prejudicial error on the point that the court had failed to take into account the bond between Lexi and her de facto family and the harm that she would suffer from breaking those bonds, and failed to take into account her individual best interests. All those errors were repeated here. And the fact that she lived with appellants for 2 more years of her life, she grew and loved and laughed with them, she entered kindergarten, she became a person with an entire world and relationships that I don't think this court can ignore.
Well, who represents her best interest? I mean, you're making an argument, and it's a solid, persuasive argument based upon the record. But she has counsel who is her guardian ad litem.
Correct.
It's her counsel.
Her counsel
Makes the determination of what the child's position is. The child's position is, in this case, that family and equal preferences dictate that her best interests are to go to Utah. Isn't
And that's
that
a
in
legal
and of
argument.
itself enough to overcome?
I disagree, Your Honor. Respectfully, that's a legal argument, and the arguments of counsel carry the weight that they do, but they're not evidence. It's the court's job, and there are a number of cases on this point, it's the court's job to determine what's in the child's best interest. It's the child's advocates.
But we certainly take into account the guardian ad litem's views, right? We have to take those into account, just as we take into account the views of your clients, correct?
Correct, and I think it's also appropriate to take into account that in this particular case, the child's counsel refused to represent the child's wishes to the court in violation of California law. I think it's telling that at every step of the way, child's counsel objected to us developing evidence relevant to the harm that would be caused to this child from removing her. And so, yes, child is represented as she was in 2014. Nothing has changed. The child's counsel has always opposed our view and has always argued that ICWA dictates placement. But in 2014, child's counsel was arguing that that was because her best interest could not be considered under ICWA, and because the bond to her parents could not be considered. This court corrected that error and remanded for what was supposed to be a prompt disposition of placement, and what ensued was, frankly, a long trip through the looking glass, where we tried to get a hearing. We tried to develop evidence germane to this court's holding.
We agree with that. But I think we need to make the record clear. Your clients they're represented by counsel, never objected to a single hearing date once it was set. They didn't come here and ask us, as I recall, and if I'm wrong about this, please tell me. They never came here and asked us to order the juvenile court to move to set an earlier hearing date. Despite the fact that every time you've come here, all right, sometimes within minutes of you filing a petition, you've received stay orders and other orders to ensure, as best we can, the proper resolution of this case. Your clients just didn't do that. I think that has to be clear. They didn't go, Judge, we object. This can be done
We
in
didn't
10
seek
days.
extraordinary relief for the failure to set a hearing more quickly. But the point is that it was respondents that caused
And
the
incidentally,
delay.
the fair argument can be made on your part that is subject to an abuse of discretion standard review, and we may have concluded that that was not an abuse of discretion. I understand that.
And given the change of bench officers, which was not because of us, it was because Father moved under 170.6 to get rid of Judge Pellman on remand. I mean, the delays were not occasioned by us, and I don't think this court...
I just do not agree with you about that. I'll tell you, in the next 72 hours, in Los Angeles Superior Court, there will be criminal defense lawyers who are going to object to the date, and we move to dismiss. Now, we don't have dismiss or anything like that. The point is, lawyers are charged with responsibility. If a matter is not being handled timely, to object in civil cases persons can, depending on the circumstances, and again, it doesn't apply to our situation, move for preferences under Code of Civil Procedure Section 36. Lawyers in this county and in this state object all the time to dates which are selected by a court. And I remember, I was driving in this morning, I was thinking, once I was in Santa Monica, and I was representing a plaintiff, and the judge was putting over the trial date for a year. And I went in, I deserved an Oscar for the acting I did, but I was objecting. I was going, Your Honor, please, my client is horribly injured. It was probably an exaggeration, Michael.
I think the transcript that you have in the record from July 2015 reflects a colloquy between trial counsel for my clients and Judge Trendacasa, who of course was the second judge on remand, in which he confirms on the record that he had been since December seeking to move the case more expeditiously without success. And no, he didn't seek extraordinary relief in this court, but I don't see how that can remedy.
I'm not saying the failure to seek extraordinary relief is determinative.
Okay.
My point is but coupled with the fact that to start pushing aggressively for an earlier hearing date, and you know what, let's be candid about it. I mean, it was in your client's interest to love the child with them because your clients love this kid and they love her dearly. And it was in their interest to have the child with them. Now, there's competing demands there, and I've made it clear earlier. I'm not suggesting your clients have done anything sinful, but there's an intellectual dissonance, as I indicated, to complaining about delays when there's not aggressive action taken by lawyers licensed to practice law in California, when they are not aggressively pushing back when courts take too long. That's all I'm saying.
Okay.
I'm not accusing you of disingenuousness.
I take your point and I understand, but here we are, and respondents didn't do anything to move this along more quickly either, and it would have been in their interest, presumably, to do so if they respected the child's right for permanency.
Let me just interrupt you here. You've used about 23 minutes of your time. You do want to reserve the rest of it for rebuttal?
I would, Your Honor.
That's great. Thank you, Ms. McGill. Thank you.